SEC committed gross abuse of power. Another CoinDesk article. A federal judge has ruled that the US Securities and Exchange Commission must pay legal costs for Debtbox, a crypto company, after finding that the SEC engaged in a gross abuse of power in its case against the company. Sandy, you are undoubtedly our go-to person here. Tell us about the ruling and the challenges and responsibilities of regulatory bodies in this space.
This is something that I would find very hard to believe that would happen in Australia. I think in the US, there's much more of that adversarial culture going on. Like in Australia, the rule I believe is the same here in the US. When you're a lawyer or a barrister arguing in front of a court, you are first and foremost an officer of the court and then a legal representative for your client. So that is to say, even in the pursuit of your client's interests, you may never mislead the court because you're a court officer. That rule is probably a lot more strictly followed here. I think it's a lot to do with the legal culture as well. There's no barrister here in Australia, or no reputable barrister in Australia, or lawyer for that matter, that would willingly try and mislead the court because the client asks you to. But I think in the US, it's very different because of that more of that focus on the adversarial side. Just some of the stuff I hear coming out of Trump's lawyers' mouths. I just don't know how they make some of these statements. But look, this is, I think, a case of that, where the SEC the lawyers in this case have clearly overstepped based on the judge's comments. They have said things that about where the funds have moved to, etc., that simply weren't true, and they have misled the court to try and get that result of freezing this company's funds when really they didn't have the proper evidence to show that funds are being moved, are likely to be moved. I mean, that's really what this judgment comes to. It's got nothing to do with the merits of the case itself. It's purely about that freezing order that SEC wanted, which should never have been issued if facts were more accurately presented. As the company says, they were never moving the funds. There's no evidence that they were trying to move funds offshore. So there was actually no basis for the freezing order. And the judge agreed to the point that they've asked SEC to pay the costs in this case, and basically got a very serious talking to in the judgment. That's the kind of thing, like, at least in Australia, that's the kind of thing that could amount to unsatisfactory professional conduct or unprofessional conduct. It could be the sort of thing that the judge, you could even be contempt of court, or you might potentially lose your license over this. Like, this is not the sort of stuff that you would do lightly, and that is like misleading the court intentionally. So again, I'm surprised to see this, but I have seen this kind of thing happen a lot more often in the US court system, where it seems lawyers are willing to go further for their clients.
Yeah, I mean, this is the type of story that it seems like we're missing something. There's some people that are just that brazen, but I would be very surprised, like you, to hear about something like this happening here. This case, it also brings up the SEC's approach to date of regulating by enforcement. And obviously the SEC is a very large institution, so there are probably multiple teams doing this type of work. Ruling by enforcement is one thing, but trying to pin down a business by misleading the court is another thing entirely. And it just boggles my mind that this even happened. And I'm glad the judge, gave him some harsh words. And, the SEC's official response was, we're reviewing the decision.
Yeah. There's another interesting point here, because there's a split in the profession in Australia between barristers and solicitors that doesn't exist in the US. What that means for a government entity like the SEC, though, I believe what will happen is that the SEC the internal counsel, they will say, internal counsel who also is a solicitor for SEC, may well just go ahead and be representing SEC in this case. Whereas if it was in Australia, you have the government solicitors, yes, but then they will also hire an independent barrister to do the actual court work. And there's a sort of stopgap there where the barrister will say, well, hang on a second, look, I'm not misleading the court here. You're not giving me the right evidence. I deal with judges in other cases. Like I'm sometimes hired by other lawyers. Like I'm not willing to risk my career to mislead the court for you. Whereas for the SEC, it's just like, well, like if it's an internal lawyer doing it, they may actually be pressured to go ahead and do this by SEC's internal department. So that's another thing that I think differentiates Australia and the US in this kind of scenario.
True.
Yeah, that's a good example of one benefit of having a split profession. I think it confuses a lot of people who are not in the industry. And to be honest, it confused me for a while.
Yeah.
But, that's one sort of inbuilt protection against something like this happening that exists in our industry, but not over there in the US.